Hi, everybody. This is Andy. It's the afternoon of July 27th, 2020. I've got two cases to review with regards to Canadian immigration. I'm doing this for an online course that I'm doing. Please note that I'm not a lawyer, and everything I'm about to say is my opinion and what I've assembled from various documents that I've put together for this presentation. So please do not misconstrue this as any type of legal advice. So the first case I'm going to cover is Malfeo versus Canada, and this was in federal court back in 2010. Very unfortunate situation. Mr. Malfeo was addicted to drugs, fairly long criminal history, and had some tragedy in his family too. But what happened was that he was issued a deportation order, and the immigration division and his counsel agreed to a joint submission, which was brought forward to the immigration appeal division. So what happened in the immigration appeal division was that very little was apparently written up with regards to their decision not to grant the stay of deportation, and they wanted the IID wanted the deportation to proceed. So then this particular case is brought forward for judicial review. And in regards to the background, Section 67 of IRPA says appeals allowed, and 67, I think sentence B says appeals allowed based on principle of natural justice has not been observed. And in Canada, the principle of natural justice and procedural fairness are fairly intertwined. And actually, just as a side note, so I just read out Section 67 of IRPA regarding principle of natural justice. I noticed that the equivalent section in the refugee, regarding the refugee appeals, I don't find that particular sentence there. So I wonder, and I know if you're a refugee applicant within Canada, you have charter protection. So I don't quite understand if that omission is on purpose or, I'm guessing it must be covered in another area. So that's an outstanding question for me. But anyways, back to this case. So let me just go to the next slide, and I'll go here. So as you probably are aware, the Vavilov decision came down December of last year. But even before that, the standard of reasonableness and natural justice are fairly intertwined, so that uh, the decision maker must be fairly clear as to how that decision was reached. So the reading for this case is actually fairly short, and so yeah, the for judicial review, uh, the trial judge basically says that the IAD breached procedural fairness by not giving further details why a joint decision by the immigration division and the applicant was refused. So the wrinkle in this particular case was that this is a case presented not just by the applicant, but by the lower level tribunal. So, and I'm now I'm speculating. I'm really speculating. It sounded like at that point in time, the ID had thought that, well, if it's a joint submission uh, by the immigration division, I'm guessing that the immigration appeal division thought that they did not have to clarify the reasoning because this case was already made so much progress in the immigration division that they did not have to justify why they overturned it. I can only speculate because the standard of review, clarity has been, well documented well before Vavilov, and it goes back to I think Brunswick. So, so I dug around, And I found a URL, and this has been I posted I think for a while, with regard to natural justice, and just to show how natural justice and procedural fairness are intertwined. This website is regarding the Canadian citizenship and I think the spousal applications. I'm not sure, but here's the URL. Let me just go there really quick. I brought it up. Yeah, for citizenship applications, and they outline uh, 12 common rules for procedural fairness. So one is just to start with notice disclosure, and then number 12, scroll down here, is the right to reasons. So, so where there, and it goes on to say, the right to reasons exists primarily when applicant has right to make an appeal or seek judicial review regarding a decision on a case to know the reasons for the decisions in order to properly prepare for appeal or judicial review. So this particular sentence says judicial review, but I would speculate that the right to reasons would also apply at the tribunal level too. So that's one reference. And I thought, since this is still posted by the Canadian government, I thought these are fairly good guidelines to follow. And again, one outstanding question I have, and I'm probably going to bring it up in class, is to why this strange procedure? Why was the joint submission even brought forward to the IAD? Couldn't the immigration division have decided on their own to rescind, to make the removal order unenforceable? So to emphasize that, I dug around a little more, and there's another URL, and then from the 2016 decision by the Supreme Court, they also laid out a framework for testing for a joint submission on sentencing. But so it's sort of similar to this. So here's the URL. But what's really interesting, they have a framework where the trial judge is preparing when considering departing from a joint submission. So even though it says trial judge, I would tend to think this applies at the tribunal level below that too, since it's case precedent, right? And number 6 is basically re-emphasizing what we've been discussing in class from Babylon and Brunswick. And number 6 it says provide clear and cogent reasons for the decision. And obviously the IAD did not bother to do that, perhaps thinking that there's already the reasoning for the joint submission was laid out, but they did not agree with that, and maybe they thought that there were points of that joint submission that were in their mind. But in this case, that decision was obviously overturned. Uh, so uh, so just to reemphasize, and I forced myself to write this down and realize it was a typo here. Outstanding. That's off the key. And why was it, so number one, why was there a need for a joint submission to the IAD? Couldn't the immigration division make that decision by themselves? And then because of that, is there a flaw in the legislation that they had to submit a joint submission to rescind the removal, to make it unenforceable? So uh, that's my summary of this case. I'm obviously don't have all the answers because this the reasoning for the joint submission, that to me that's you know it's in my mind hasn't been answered yet. So that's something I'll need to think about as we move forward. So I'll do the next case now. So the next case, and thankfully both cases are fairly short to read. Um, as a side note, there's been other cases where this goes on and on. I only have two for this week. So this is a case where I think it's a Ms. Lu. Ms. Lu. She had she had gotten her permanent residence, but she decided to go back to live in China for I think for some medical treatments, I think acupuncture or something. And because of that, she failed her residency obligation under URPA Section 28. So she raised this issue all the way to the federal court. And this one was fairly quick. And she had raised a few issues. One, let me see. Uh, Actually, I thought this is kind of an interesting reading because, well, to me, and this is just my opinion, she was trying to throw everything at and the kitchen sink to try and stay. She wanted the immigration division and the appeals division to consider uh, pre pre-removal risk assessment, her risk as a woman as a subclass. So she tried a few different avenues, but as we discovered in Vavilov, and the good thing about this case, this came after Vavilov, is that one of the findings in Vavilov was that you know when you do a case review, uh, you know the the uh, the administrative law, I guess on the federal government side, um, you're not supposed to like essentially cherry pick line by line, and and in the actual cases, is line by line treasure hunt for an error in law. You have to take it in its totality, and Ms. Liu tried to pick apart different, I guess, arguments in the procedural fairness letters to, you know, where Ms. Liu found that to be incorrect. And this trial judge said, well, no, I mean, they were just responding to what you had said. And frankly, for one, she, I think, even appealed to Section 97, 96, and 97 for refugee protection. But if you applied for refugee protection, why were you in China for 3 years? And if you were questioning, uh, you know, that plus some other issues, well, why did you go back? So basically, this appeal was denied. Uh, I found this one kind of funny actually because it's she didn't really have much of a grounds, I didn't think, for the appeal in the first place, but she tried, right? So, anyways, thank you very much. Sorry that I rambled a bit. I'm obviously a little more clear with the Excel stuff. So, see you for the next case review, and or not, I'll see you for the next Excel video.